This is Michael Popok, Legal AF. Did you know that Donald Trump's grandfather built hotels for miners in the Yukon Territory of Canada in the early 1900s? You might be thinking, I didn't know that, and Popok, why do I even care? Sort of what Judge Engoron said today in court, as Don Jr. spent almost his entire presentation, there's no other way to put it, about the Trump family with a slideshow to take us from the early 1900s and then have him comment and give running commentary on all of these gleaming projects and buildings and all of that. To which Judge Engoron waved his hand at a certain point in response to an objection by the New York Attorney General and then by Chris Kise, and said to the lawyer for Donald Trump, you're going to object to the New York Attorney General asking a cross-examination question about 40 Wall Street? I just listened to an entire morning of irrelevant information about the family. So I don't know what the lawyers for Donald Trump were thinking, that at this point, after 6 full weeks of the New York Attorney General's scathing evidence presentation, that now was the time for like a vacation video from the Trump family to just have Don Jr. in a smarmy fashion that is really just who he is, just sit there and talk about, oh, Mar-a-Lago is one of the last American castles, and this is a beautiful building, and it's now worth $3.1 or $1.3 billion. This is a guy who, during his cross-examination as a hostile witness for the New York Attorney General, said he did not know any of the valuations that were listed on his father's statement of financial condition, which are at the heart of the entire civil fraud case. He took himself out and disqualified himself from giving any pertinent, relevant testimony. So what did that leave him with? You know, it's funny, Ben Meiselas and me on our recent edition of Legal AF, we're talking about what we would think Don Jr. would be able to say. Hadn't he already shot himself in the foot, if not the head, about being a witness, a precipient witness with knowledge of anything, since he already took himself out of the running and disqualified himself on the stand during earlier examination? What could he possibly say? Well, now we know. He was going to talk about valuations that have nothing to do with his father's personal statement of financial condition, which is at the heart of the fraud, and just be talking about other things. I felt like I wandered into another movie. Like, this is not the movie that that Don Jr. is supposed to be starring in. That was the civil fraud case against his father related to a period of time. To have him sit there and waste the court's time for the entire morning and a little bit of his afternoon of his testimony, to have Don Jr. just sit there like he's some sort of Disney World tour guide on a bus. On your left is Mar-a-Lago, on your right is 40 Wall Street, and that's I mean, come on, you can get a better sense of where Donald Trump's properties are from a celebrity map than you can by listening to Don Jr. And it had to be disheartening for the Trump Organization lawyers and Donald Trump's lawyers to hear, in kind of a withering sarcasm, Judge Engoron say towards the end of Don Jr.'s testimony, I just listened to an entire morning of irrelevant information. And then what I like about Judge Engoron now, and in general, the way he's presided over the case, is he is even-handed. Even if the Trump family want to get this evidence in, relevant or irrelevant, he's going to let it in. Last week, I did a hot take about the judge allowing 4 potential expert witnesses for Donald Trump to testify, even though there's really no issues left in the case for them to testify about. Because the judge already ruled that there was persistent fraud on summary judgment 6 weeks ago, and the only issue left is intent of Donald Trump to commit those frauds. And these experts, of course, can't comment about intent of somebody, the subjective mind of someone. So what are they going to testify to? Oh, this is how appraisals work, Judge. That's irrelevant. This is how insurance is bought in America. Well, that's irrelevant. And so, but the judge said to the New York Attorney General last week, and he repeated the same admonition this week, do you want to have a reversible error issue? Do you want to have another of these trials? Or do you want me just to let the evidence in and give it whatever weight, wink, wink, I'm going to give it as the trier of fact? And last week, the New York Attorney General sat down, and those 4 witnesses are going to testify over the next few weeks. Same thing happened today. Today, the judge, the New York Attorney General jumped up and down and said, what is all of this testimony about, this issue about the 1900s and the Trump family property? And we object, Your Honor, to the current evaluation or current valuation of the Doral, Florida Country Club at $1.3 billion because it's well outside the period of time of, it doesn't matter what it's worth now. It's matter what it was reflected on Trump's personal financial statements and statements of financial condition during the relevant time period, and that's not this. So why are we letting this evidence in? And the judge looked at them, and here's the quote. I took it down. The judge says, do you really want to give them this issue on appeal and have another trial, or we'll let it in? And the judge just let it in. I also thought it was interesting that Don Jr., when they asked him in cross-examination, a cross-examination, by the way, by, again, the New York Attorney General and Colleen Faraday that lasted 5 minutes. Now, let me tell you, as a practicing attorney for 32 years doing trial work, the reason they did such a short period of time in cross-examination is they didn't think Don Jr. did anything at all to hurt them, that he didn't land a glove on Letitia James's case. That's why you almost say, I'm sure one of their options was to say, no further questions, Your Honor, which is has a lot of bravado in that. You signal to the judge or the jury that nothing that guy just said hurts me at all. But they decided to ask a few questions just to sort of embarrass Don Jr. Like they said to him, isn't it true that one of your holes, the 18th hole in one of your golf courses, fell off into the sea? like the hole collapsed and disappeared? Yes, that's true. Isn't it true that there's a Hawaiian property that used to have Trump's name on it that they're paying millions of dollars for to take Trump's name off of it because they're embarrassed? Yes. Have you heard of senescent cells, also known as zombie cells? These old, worn-out cells no longer serve a useful function for our health, wasting our energy and nutritional resources. These zombie cells tend to accumulate in our bodies as we age, leading to the aches, slow workout recoveries, and sluggish mental and physical energy associated with that middle-age feeling. Our sponsor, Neurohacker, packs 7 of the most science-backed senolytic ingredients into one formula called Qualia Senolytic. And you can take it just 2 days a month for fast, noticeable benefits and a much better aging process. Senolytic ingredients are science-backed to support our body's natural elimination of zombie cells. My body and energy levels feel about 15 years younger after just a couple of months of adding Qualia Senolytic to my diet. I love how easy it is to take. Having more physical and mental energy for my family and friends is such a win in how I show up for those I love. My productivity has doubled. I feel invigorated and enthusiastic again, with the daily drive and enthusiasm to get things done. The formula is non-GMO, vegan, gluten-free, and the ingredients are meant to complement one another, factoring in the combined effect of all ingredients together. It's also backed by a 100-day money-back guarantee, so you have almost 3 months to try Qualia at no financial risk and decide for yourself. If you're in your late 20s or older, adding Qualia Senolytic to your diet can play a crucial role in combating negative aging symptoms. Go to neurohacker.com/legal for up to 50% off Qualia Senolytic. And as a listener of Legal AF, use code LEGAL at checkout for an extra 15% off your first purchase. That's neurohacker.com/legal to try Qualia Senolytic with code LEGAL and start aging on your terms. And then they jump up and down because the New York Attorney General asked Don Jr. the question about 40 Wall Street, this big premier property. Now, by the way, I've been inside of 40 Wall Street. I have a friend that has a law firm I will not name inside of 40 Wall Street. First of all, it's not 73 stories high. I've seen the elevator bank. I've seen the numbers. I'll just leave it at that. And my friend's on a pretty high floor. Secondly, they love talking about this building, and they always get it wrong. The occupancy rate that Don Jr. testified to back a week ago when he testified with the New York Attorney General is about 70%. He said 90%. It's a big difference, 70%, 90%, when you're doing valuation calculation for real estate. That's the first problem. But now, as we learned a couple days ago, it's been put on a list by the lender, right? It's called a servicer's watch list. The way these things work is, I won't bore you with all the details, but 40 Wall Street was part of what's called a commercial mortgage-backed securities lending, CMBS lending. Its loan was part of a lot of other loans that were stitched together on different, we call them different shelves or different pieces. There's a shelf for the entire security. These different loans are placed on that shelf. There's the A loans, there's the B loans, and the C loans, depending upon the quality of the asset. 40 Wall Street was probably the A piece, if you will. And then they kind of stitch all these things together like a Frankenstein, and people buy an interest in the loans being repaid. And the banks that made the original loans, and you can name all the major banks or capital companies, but the loans themselves are complicated and they have a lot of pieces. So you hire another company to service the loan, meaning to make sure the debt service is paid and the loan payments and taxes are paid and the buildings are kept up and tax returns are provided, for personal guarantees and all of that. Make sure all the I's are dotted and the T's are crossed. That's called a servicer. And if your building falls into a problem, so they can put you on a servicer watch list, which means they can ask for more money to be paid in escrow because they don't trust you and the like. And apparently, whether it's because of all the fraud that's been alleged and fraud proven already in the case, remember, a persistent fraud already proven, and the judge already ruled, they put them on a servicer's watch list. Government got all upset when Don Jr. referenced the issue about, it's only because of this summary judgment issue and going against us. That's the reason we're on there. So they had a whole fight about that. And again, Judge Engoron demonstrated once again, he is going to bend over backwards to let in all of the evidence, including anything that Trump wants to let in, relevant or basically irrelevant. Today being a basically irrelevant Don Jr. testimony day. And why is he doing that? Because he doesn't have a jury that he's there to protect. Judges are gatekeepers of evidence and expert testimony, especially when there's a jury. But when it's just the judge making his own decisions as the trier of fact in a bench brief, he's like, I'm a big boy, a big boy or big girl. I can make my own decision about it all. And I'll give it the appropriate weight. This is the phrase. I'll give it the appropriate weight that it deserves. Relevancy, irrelevancy, credibility, and the like. That's the judge's prerogative when they are also the trier of fact in making the ultimate rulings in the case. So where you might be saying, Popok, with all experience in that kind of courtroom, how do you think Don Jr. did? Not well. It really just seemed like, it's like when you have a suitcase, you don't really have any business or documents, so you stuff it full of newspaper. It was a lot of newspaper stuffing today. It had nothing to do with the case. It was 90% irrelevant. If they thought Don Jr. was the right person to be the roadmap witness to the Trump family legacy and talk about old Grandpappy Trump in Canada and the Yukon building hotels, I mean, I guess it's a heartwarming story if you had a jury present, but you got a judge. And the judge doesn't want to hear about the 1900s. Even the New York Attorney General lawyer stood up and got a laugh, and he said, well, if they're going back to the 1900s, are they going to waive the statute of limitations and let us prosecute way back then? And people laughed about that. But seriously, folks, what are we doing? I let off the hot take with that little tidbit about the Trump family, and you guys rightly should have said, who cares? And that is where we are so far. And if that's the best that they want to try to recenter the case, reorient the judge to their side, you pick the best witness to do that. You put your best witness first, right? We believe in recency and primacy, or primacy and recency. Put the best witness first, put your second best witness last, and sandwich everybody else in between and end on a high note. That's how you present a trial. That's how you get the momentum of the presentation. So their primacy witness is Don Jr. to do a bus tour through the Trump family, Trump family land. Come on. So we'll continue to update you on all things related to the trial. There'll be probably another 3 weeks of this before the Trump family will rest. The New York Attorney General will do a rebuttal case, I'm sure, probably last another 2 or 3 days. And then it's over to Judge Engoron without a jury to make the ultimate decision if Donald Trump has not only committed one count of persistent fraud under New York's Executive Law 63-12, but whether he's committed 6 other counts with intent to commit those frauds under New York Law 63-12 for insurance fraud, financial statement fraud, books and records fraud, and conspiracies around those things. And then the judge, if he finds one or all of those things, then he's got to decide on remedy that's appropriate. Remember, the New York Attorney General wants to take all of the money and values for properties that were ill-gotten, should not have been obtained by Donald Trump, take that away from him. And that number could be $500 million or more. The New York Attorney General will put that on in their rebuttal case, I am sure, on a remedy section. And also decapitate the company, put them out of business, death penalty for the Trump organization, make sure the Trump kids, Trump, and all of the people that work for Trump never serve in positions of being officers or directors of New York corporations, switch out the trustee for the Trump organization who controls all of his assets and everything else. Again, decided by the judge. We'll continue to follow all this on the MeidasTouch Network, exclusively here, and on Legal AF, a curated podcast we do at the intersection of law, politics, and justice on the MeidasTouch Network, Wednesdays and Saturday nights at 8 p.m. Eastern Time, and on audio podcast platforms wherever you get it. Give me a thumbs up for this particular hot take. Until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.